PA 233, the renewable energy siting law, is part of a package of bills that went through in last fall. That PA 233 is the first one numerically. It gives Public Service Commission authority for large projects, and we'll go more into that in a minute. There was also, though, PA 234, which amended the Zoning Enabling Act, referencing PA 233, but also, this I feel like is underreported, if there is a county that already has given land use approval, special land use approval to a project since 2021, it effectively affords non-conforming status to that, effectively in perpetuity, as long as the developer has spent at least $10,000, which for these large projects, they've spent at least $10,000. But also, the PA 235 is part of why we see PA 233 and 234. This does a lot of things. It increases the rooftop solar cap, so now more people who want solar on the roofs can have access to that. But it also sets a statewide standard that the utilities get 50% of their power from renewable sources by 2030, 60% by 2035, and a separate goal is, or standard for the utilities to meet, is 100% clean by 2040. And that clean is separated on a different line because that clean includes nuclear, carbon capture with sequestration. Additionally, and this is important, sometimes battery storage, it's not always talked about as a renewable, but it falls under the PA 233, so I want to mention it here. This PA 235 requires the utilities to have 2,500 megawatts of energy storage, big batteries, by the end of 2029. There's a whole bunch of other bills that were part of the package too, but to keep on time, I'm gonna move on. Okay, so PA 233, the siting law, what does it do? So I already said it grants the Public Service Commission new authority to issue certificates, effectively local land use approval for renewables projects at designated thresholds. So I've shown those designated thresholds on the side. 50 megawatts solar, think like at least 300 acres or more, usually a little bit more than that. 100 megawatts nameplate capacity for wind energy facilities. That's about 30 modern turbines, maybe a few more than that. And then 50 megawatts nameplate capacity for energy storage facilities, or 200 megawatt hours. Energy storage doesn't take up much land. 50 megawatts of energy storage could be sited on 5 acres. So this law is really applicable everywhere, especially for the energy storage part. I want to highlight, going back to the kind of bullets here, the law gives developers an option to go directly to the Public Service Commission rather than local zoning, but they don't have to go. Some other states you have to go. This provides an option. Also, it covers, like if projects that are existing right now want to expand or to repower, and repower is effectively old wind turbines, this is where we are, like take them down and replace them with modern wind turbines, that's repowering. The law grants them authority, developers the authority to go through the state too. And as mentioned, it's effective November 29th. Okay, before I go into any more about this, I'm focusing today on what now rather than how we got here. People probably, actually, I understand that there's like posters with my picture on it circulating in some counties right now. People probably have very different opinions about how I feel about this law. I will let Mac attest to kind of my advocacy in this. You can also read my op-ed about this. So the op-ed was, maybe we should think about something else, just to be real clear. But instead what I want to focus on is like, what do we do now? So what does this mean for you? The other thing that I just want to address is that there's a whole bunch of unknowns right now. In particular, we're kind of at a waiting period on the one hand, because we know that there's a ballot initiative circulating and trying to get signatures and to get on the bill, or to get on the ballot to overturn it. They've got until the end of this month, this next month. But also the Public Service Commission right now is having a stakeholder process to figure out how they are going to implement the law if the ballot initiative is not successful. And so I point that out in particular because they, on the 5th of April, they came out with the MPSC staff came out with their first recommendations of how they intend to implement the law. It includes providing public notice and public meetings, effectively who needs a CREO, use of intervener funds and application fees. And I would just encourage you, Matt provided some comments to that, but I would encourage everyone to take a look at that and to chime in yourselves.